Anyone charged with a misdemeanor alcohol or drug-related driving offense will have bond conditions set by the court at the arraignment. The arraignment is the first stage of the court process where the accused is advised of the charges and given an opportunity to plead. In virtually all cases, formal reading of the charges is waived, and the accused stands mute. The court enters a plea of not guilty and schedules the case for the initial pretrial. The arraigning judge or magistrate will also set bond conditions. In general terms, the bond conditions are aimed at accomplishing two principal goals. First, ensuring the appearance of the defendant in all future court proceedings. And secondly, protecting the public welfare against any threat that the defendant's release could pose. Now, in most cases where someone stands charged with a first offense, the court will set a personal recognizance bond that allows him or her to be released without having to post any cash. However, bond conditions related to the abstinence of alcohol or illicit drugs can vary widely from court to court. In virtually all drunk or drug driving cases, the bond conditions will require no consumption of alcohol or ingestion of any non-prescription drugs. The variable in the bond equation will be the extent of pretrial alcohol and drug testing, because some judges won't impose any pretrial testing, where others in the same district court may impose random testing as often as 4 or more times a month. In the case of an individual with one or more prior alcohol or drug-related offenses, the court may impose daily PBTs or an in-home or portable monitoring unit. And bond conditions may also include random urine tests for drugs. But the important fact to keep in mind is this: bond conditions may be very difficult to modify after arraignment. Therefore, in my view, it's ill-advised for anyone charged with an alcohol or drug-related offense to appear for arraignment without counsel. An experienced defense attorney will likely know the tendencies of the individual judges throughout the district courts regarding pretrial testing, and can make valuable recommendations that are unique to a client's history and circumstances at the arraignment. The end result may be bond conditions that are much less intrusive and burdensome than would result in the absence of experienced counsel.